Looks like we're live here. Well, hello everybody. It's me, Brian. That was me checking to make sure my microphone was on. Welcome. It is Monday. It is 6 p.m. Eastern Time. I'm here in fabulous Dublin, Ohio, right outside of Columbus. I'm from the law firm of Sam Shehab and Associates. And as usual, we're here to talk employment-based immigration issues today. You will note that my dear friend and partner Sam Shehab is conspicuously absent. He is away on some business today. Fortunately, late last week, we were able to record our topic for you. So what I'm going to do is I'm going to hand it over to that right now. I'll be back on the back end to talk about, well, take your questions, of course, as well as talk about the very, very interesting Maybe It's a Bulletin that came out late last week. I will see you guys soon.
Good day, everybody. When you listen to me, it's going to be Monday at 6 o'clock. Welcome to our weekly get-together. My name is Sam Shehab from the law firm of Sam Shehab and Associates. We're going to be talking about today 5 challenges for long pending adjustment of status. With me is attorney and my partner, Brian Burke.
Hello, everybody. Thanks, Sam. So let's say we get right into it then, huh?
Yes, absolutely.
So the bottom line is the visa bulletin, it's not moving. And there are lots of people who got to file green cards in the last couple years, and now that their date has screened backwards, they're stuck. And there are fun and unique challenges that come with having a long-term pending green card. And we're going to go through and sort of the most common questions we get asked about.
Yeah,
really.
the lingering nature of an application for many years brings about stress points.
Yeah.
People evolve, people have children, people buy houses, people have opportunities somewhere else, and this adjustment of status, that cloud over your head that is moving with you all the time, gets heavy.
Yeah.
And we want to talk about the 5 things we've observed through our practice that are current concerns or issues, and hopefully...
Yeah, if we're talking to somebody about a long pending green card, we're probably talking about at least one of these things with them. Yeah.
So let's start with number 1.
Yes. A true classic. Do I maintain H-1B or do I use my green card EAD and leave my H-1B status behind? So for anybody who's not aware, you can't be on H-1B status and use that green card EAD. The rules of your H-1B status are that you are allowed to work for your H-1B employer pursuant to the terms of that LCA that comes with your H-1B case. And the green card EAD is, anything but that. The green card EAD allows you to work for anybody in any capacity in the United States, and that if you're using that, you're not on H-1B status is the bottom line. And some people, they choose to use the green card EAD for its versatility, and some people choose to maintain their H-1B status for protection. What do you say about the protection of maintaining your H-1B status, Sam?
Well, Brian, before I talk about the protection of maintaining the H-1B status, I want to share an observation.
Okay.
It's my observation, not Brian's. Brian may have a different observation.
I'll let you know if I agree with it.
Exactly. It's my observation that people with time eventually get off H-1B and get on EAD for various reasons. Now, the theoretical recommendation that Brian wants me to tell you, which I will tell you why keeping H-1B is better, is that second layer of protection should there be a problem with the adjustment or a mistake by USCIS by which there is a improper denial, etc. Because you stop working if you are on EAD, and then you're not in legal status in the U.S., and fighting it is emotionally taxing and very risky to overcome this denial.
Yeah, point is, if you're maintaining your H-1B status and your green card is denied, well, you can fall back on your H-1B, you're fine, you can continue living and working in the United States, and it gives you the opportunity to be in the United States and fight that green card denial. And it is, you're right, it's my kind of baseline recommendation, but I fully agree with you that, Most people, if they have a long pending green card, eventually they leave their H-1B status behind for practical reasons. Usually there's essentially more opportunities out there for using that green card EAD. There are plenty of employers who won't touch an H-1B visa with a 10-foot pole, but as soon as you show that unlimited work for anybody EAD, they're happy to hire you, and there's usually financial incentives, location incentives, any sort of incentive.
The alternative is 2 adjustments.
Yeah.
So if you qualify for EB2, you can also file an EB3, I-140, and I-45 adjustment status for that EB3, and now you have 2 adjustment status, and you can move away from the H-1B if you have to, and if it's advantageous for you to do that. And having 2 adjustment status, if one get dinged by the government, you have the other one to keep you legal and working.
Yeah, in theory, if different adjustments of status, one flaw in another might not impact the other, especially depending on.
They don't decide both of them at the same time.
Exactly, for sure. Okay. They very much take some time to react to what happens in one case in another, if at all.
The ultimate guidance on H-1B versus EAD is you have to weigh pros and cons, and you have to understand that there is not one better than the other. In the textbook answer, the H-1B being maintained is a great idea, but it is very restricting. So you get a job for $20,000-$25,000 a year more in a town that you would like your kids to go to school in, right?
Yeah.
It's a no-brainer.
Yeah.
It's not only the law; it's your personal situation.
Yeah, I usually tell people, here's the immigration lawyer. This is the first advice you learn in employment-based immigration when it comes, but fundamentally, immigration should not rule your entire life, and there's other factors at play.
All right. So which one is better, EAD or green card? It depends.
Depends upon the factors. Yeah.
Perfect.
All right.
Number 2. Change in technology or job description. How does it impact my green card?
Yes.
So that's a big one, and that one will happen to everyone, Brian.
Yeah.
I haven't seen anybody with a long-term or long-pending adjustment status that have not experienced a migration in the job description, or a outright change in the job description, or a change in the methodology, technology, etc. That now all that language that in the labor certification there, or half of it may be moot, irrelevant, or been replaced by something else.
Yeah.
And is the green card application that they have filed good at this moment?
My answer to that is, as soon as I think about changes in technology or job description, I would think, when has that change occurred? If it's changed, long after your adjustment status has been filed, when you're in the realm of portability being possible, you have some real flexibility there. You have INA I-45 portability. You can move to a same job, another job,
or
in the same or similar job. So that kind of more or less fixes the problem for me. However, there's a question of if you're with the same company, they're still offering you that same work, and does it not match up? I guess the fundamental question is, do you have to go back and do a labor certification and I-140 again?
Yeah, sometimes the job, I don't want to go too far in the past, but sometimes the job it changes significantly.
Too much, such that you can't even call it a same or similar occupation anymore. Yeah.
I think it's a judgment call. Yeah. Good news, bad news, right? Good news, no impact on your priority date.
Yeah, you retain your priority date.
Probably the timeline within which you will get the green card is going to be the same, but now you're going to have to go through an expense again. The employer may not be willing to pay for it, so there's all kinds of issues. If the job has changed to a point of discomfort for you, you probably need to consult with an attorney and have them advise you on that job description and talk to the employer.
Yeah.
If you become uncomfortable with the change, most likely a new labor certification may be needed. Why do I say that? Because you're the expert, not me, on what you do. I cannot tell you that you've changed significantly. You will tell me what changed significantly.
Yeah.
Based on that, I think a new labor certification may be necessary.
Yeah, I mean, it's not incredibly common, but sometimes we have to talk to people and let them know, it's been a while. Your job has usually this happens before filing the green card application, though, is really when this happens. When you hit the post filing, again, I think you have the flexibility of portability.
What's the obvious one? The obvious one is I used to be a senior systems analyst. Now I became director of technology.
Yeah.
So that's the obvious one, right?
Yeah.
Now I am leading a team of teams, right? Yeah. I am on close to the top of the pyramid. I consult with the owner. I consult with the CEO. I consult with the regional manager. I used to lead a team of 8 professionals. Now the teams that I'm leading, is a total of 125 people. That is a significant change.
Yeah.
Less significant is technology where, we do not use this C++ anymore. Mm-hmm. We use something else that replaced it.
Yeah.
If everybody kind of migrated to the new technology, I wouldn't worry as much since the whole world has migrated to the new technology. Mm-hmm. But those are the kind of...
Yeah, in theory, it's possible for... This is one of those issues for me where I don't think USCIS really digs down deep into that issue. Whereas, I think I'm relatively technologically minded. I think, if I wanted to look over everybody's green card case, I could, point out what might be inconsistencies, and maybe the government doesn't care about them for their current policy.
Under the same umbrella, but a different category, Brian, is that my change in technology and job description renders me now qualified for EB2 when I used to be EB3.
Yeah.
So now I have worked long enough. Now I'm taking enough of there's a supervisory function. I used to be a mid-level employee, didn't supervise anybody. I got a bachelor's degree and 3 years of experience when the green card was processed. Now I have bachelor's degree and 7 years of experience, and I'm supervising people. Then you can get a
new labor certification, new category, move up to EB2,
and potentially use the same experience with the same employer under certain circumstances to justify it. People say, well, you cannot use it. Well, sometimes you can, and then go to an EB2.
Yeah, fundamentally, the big challenge historically, I remember, maybe 8 years ago, we were doing tons of upgrades from EB3 to EB2 because EB2 was looking to be the faster category. The big, problem with that right now is EB2 is ahead of EB3 is ahead of EB2 on the visa bulletin, so it's less attractive right now. But I don't think it ever hurts anybody to have, to be available in both categories. Is the bottom line.
And number 3 is
it's kind of related to this one. Do I change category or do I wait?
Well, it's not related. They're a completely different question.
For me, no. I was just,
no, it's not related.
No, it's totally related. You were just talking about upgrading to EB2 from EB3, and it's kind of what
it doesn't have nothing to do with the job description. It has to do with...
You segued to the subject of doing a new labor certification, though. You were just talking about going from EB3 to EB2.
Correct, but that's for a different reason.
Okay.
One is gaining more experience. Here, one is significantly more advanced, so I'm jumping not because I gain more experience, I'm jumping because the priority date is moving. It's the EB2, EB3 back and forth yo-yo that we went through in 2021 and 2022.
Sure, yes.
Is the question.
Yeah.
And that's why it's different, I think.
Okay, fair enough. Well, there are people out there, I know of them, that they are reasonably close in the EB2 category, maybe within a year, and there's a fundamental question, do I jump down to the EB3 category, because that's where my priority date would be current, and I could, in theory, have a green card. And you have...
May I say something on that?
Certainly.
Whatever you say, Brian, and I respect what you say a lot, because you have great insight, no attorney have a full analysis because nobody can tell the future.
Sure.
And people say, do I change? What do you think? Should I change? We can guesstimate, advise. You got to make that decision. Oh, and that's the most important point I want to highlight.
Oh, that's where this conversation goes for me. So fundamentally, right now, as of here in April 2023, we are usually telling people that if you're starting a fresh labor certification and I-140 process, you're looking at about 1.5 to 2 years to get it to I-140 approval, because the Department of Labor processing time's absolutely abysmal. And what you're weighing then is really how long it's going to take for my date to become current in my EB2 in my current category versus what's it going to take to move to other category. And for some people, it's very easy to move between categories. Oh, my employer is willing to downgrade my EB2 to EB3. Great, fine. But if you have an employer that's not willing to do that, and we encounter a fair amount of those, you're looking at joining another company, going through the labor certification process again, going through the I-140 process again, you get a case in the EB3 category. And that's really, it's the matter of time. It's, there's obviously costs, your career, your time with that current company, what are your trade-offs of joining the new one, and then fundamentally having to go through the absolute pain of, going through the process again. And fundamentally, your green card with your current employer in EB2 seems like a sure thing, eventually, right? Well, as long as the company keeps you around, it's who knows. It's one of those things where it's just, for me, not just an immigration question. It's are you willing to forego the potential to get a green card sooner versus and to stay with this company versus jumping ship for riskier waters, but going through the process again and maybe getting a green card sooner. Let alone where the visa bulletin's going.
And what about within the same company? And let's say the employer is willing to do it. Do you? That may be another topic, transfer underlying basis, or a different prong here that we're going to be talking about. Yeah. But in terms of weighing your options, those are things that I think what I honestly, if I want to give benefit to somebody listening to me, is when you're considering these things, spend a lot of time understanding it and researching it. I'm sure there's a lot of information on the World Wide Web that can help you out. But after you do your homework and your due diligence and lay it out in your vision and understanding, then ask for a consultation with a good attorney that has the patience and the knowledge to guide you in their opinion and compare it to your notes, and then that allows you to reach a good conclusion, in my opinion.
Yeah.
That's a good roadmap if you get into a point where you really feel the urge to make a decision. And a lot of time, Brian, the other thing I want to tell people is, it's really hard to say it and to have people register this one because people are listening to us, do it. People are not listening to us, don't do it, which is update yourself and spend the time to learn, because you could be sitting in your job under EB2 with your, and if you're not paying attention, you could have transferred a year ago to a EB3 and gotten your green card now, but because you don't know what's going on, you're missing out on great opportunities. So keep yourself updated and current is an obligation to yourself.
Yeah, I mean, when it comes to talking to an attorney about this, I don't know, I mean, you've had these conversations more than I have, of course, but fundamentally, for me, that's usually a conversation with somebody about what the future holds. Here's what we know, here's what we don't know, and it's usually, here's my take on it. But I usually end up telling somebody, you don't make a bad decision either way. You make your decision. It's not a bad decision. It's the decision you make. It's your personal one to you. I can give you some insights as to where I think things are going, but fundamentally, it's not just immigration at play. I usually tell people, well, I'm going to tell you what sounds to me like the quickest path to a green card in my best estimation, but because that's what drives me as an immigration attorney. But immigration is not the only thing that's really running your life.
Absolutely. Number 4.
So, relevant to changing categories, how do you do it? Do you do a transfer of underlying basis, or do you file that second adjustment of status? A classic conversation we've had here, and it's one that's coming up again, is people are thinking about again to change from EB2 to EB3, where their priority date is current, in theory. Well, one thing for TUB, your final action date must be current in order to be eligible for the transfer of underlying basis. So that's one thing that sort of limits that. And you can file the second adjustment of status as long as they're willing to accept your case, going by the dates for filing. So that's one thing that can impact your decision. The TUB is cheaper, but the TUB, you get less feedback from USCIS. You don't get receipt notices. You put a letter on paper and say, please move my case from one category to another, and you hope that they act upon it. And as many people experienced during the last fiscal year, sometimes they don't act quickly, and sometimes they don't act soon enough for you. Whereas that second adjustment of status, you go back to the beginning and of the process, and if they say it takes 10 to 14 months to process a green card, well, you can't really start complaining about that process until you hit that.
But if your priority date is 4 years backed up, and you have an opportunity to file a second adjustment in another category to create that second protection. Let's say you're getting off H-1B, that's why you want to do an EB-3 or an EB-2, you qualify for an EB-2. It's a no-brainer to do a new adjustment, to file a new adjustment, because the more adjustments you file, I know they're not cheap, but the more guarantees in terms of your future in this country.
I mean, my dream for somebody is to have not just have two adjustments, but have one adjustment based upon an I-140 with one employer, and one I-140 adjustment based upon an I-140 with another employer.
My dream is a third one through a derivative with the spouse.
Ooh, yeah. So the bottom line is, though, multiple, incredibly distinct bases of this path to a green card, because
all of a sudden you're sitting in a very nice spot, unless you're writing this adjustment status on its own and you're working this EAD. It's almost like driving on 3 tires or 4 tires. You know those European cars that have this 1 tire in the front.
Yeah, Robin Reliant said the British one. I think you're thinking of.
Yes. So more tires, more adjustments, more safety, more options.
Yes.
All right. So sounds good. Number 5.
Yes, an inevitable long pending green card question. It's taking extended leave.
That is a very good question, and that's we get a lot of those questions.
Yeah.
I love the fact that people come to me and say, I'm going to take 6 months off. I never dreamt in my career that I can ever take 6 months off. I never did. But those who think about
Sam, can I take 6 months off?
There are certain things, certain things in life, outside this office, by the way, are more important than work.
Yeah.
Which is awesome. But what's the impact on the green card, Brian?
So, let's talk about the legal standard. The legal standard, once you're supposed to be in that green card job the day that a green card's available for you. That's that. There's no requirement that you work for a sponsoring employer while the green card is pending. If it's possible that you could get a green card through employment, never having stepped foot in the United States before. It's pretty rare that they come up. Usually, if somebody wants to, a company wants to try you out first before they sponsor a green card for you. But every now and again, we do on a green card. The very first day this person enters the United States, they get an employment-based green card. It's possible. No requirement that you have joined the company prior to getting that green card. However, the long pending green card, the bottom line is not being employed can raise questions with USCIS as to whether there's an offer of employment there. And I'm going to always try to favor the conservative advice saying, you're going to need an I-45 Supplement J. In theory, on 90 days notice, if that RFE comes in, I wouldn't want to find you in a position of long unemployment, especially when your priority date is current.
Excellent summary. I wouldn't even add anything to it. You're right on point on that one. And for those who thought that we only bring to you 5, well, we got a bonus.
Yes.
Bonus long adjustment of status issue, which is exploring alternative immigration options. That is something that you should always do. And the easy 2 are the EB-1.
Yeah.
And the EB-5.
Yeah, well, easy to discuss. I don't know if they're easy to meet, but let's
It's I would add to the EB-5 self-employment, because self-employment can translate to EB-5 later.
That's true, yeah.
So if you have savings or have inherited money, have resources, EB-5 is a no-brainer. It gets you into the green card in probably half the time.
Well, yeah, my take for anybody is to, if go ahead, you just type in USCIS, EB1 or EB5 into Google. You'll get a basic idea as to what the various programs are about. EB5 invests big money into a business. EB1C managers or executives work work abroad and transfer to the United States. And EB1 B is people. The professors and researchers. We've done researcher positions for people in the world of IT. You have to have some pretty lofty accomplishments, maybe a nice software patent, but it's possible to do. It's worth thinking about, I guess, if you haven't done so. Is the bottom line. Yeah.
Absolutely. Now, a kind of an extension / item number 7 that did not make it to the list is understand the Child Status Protection Act.
Ooh, yeah.
So understanding the Child Status Protection Act and looking for alternative immigration option, which item number 6, are kind of connected. All these are connected, but these are closely connected because if your child is aging out, and we have had conversations with wonderful people going through the immigration process, and they said, oh no, my daughter will not get that green card based on what's happening to me. I have savings. I would go through the EB5 program. I am already in the self-employment, or I have been running a company, or I am able to run a company, and therefore I'm going to do EB5 to protect my child, because under EB5, certain EB5 categories are current right now, and once you file that EB5, you file that adjustment, and it's very promising.
Yeah,
nothing is guaranteed because it has to be approved before the child.
Yeah, I mean, you have to have approved petition with a current priority date, but it's better than betting on the visa bulletin, hoping for Congress to eliminate backlogs or something along.
Significantly enhances the chances of the Child Status Protection Act. So, if you feel that your child is aging out, then begin exploring alternative immigration options.
Well,
you might be able to save that child's green card.
I mean, I want to go back a couple steps in our conversation. Anytime you think about changing categories, you really have to think about the Child Status Protection Act, by virtue of the fact that it may not be beneficial for your child to be for you to be in the EB2 category or the EB3 category, or vice versa. You really have to think about that when you're changing categories, because if you had a very long pending EB2 I-140 that took a year, a decade ago, it may not look so good compared to the EB3 I-140 that was approved for the premium processing, earlier this year, for example.
Yep. Well, thank you guys, and when we come back, this guy will answer your questions.
All right. And I'm back. Here I am. It's me, Brian. For those of you who missed my very introduction there, you'll note that I'm here by myself. Good Mr. Sam, a dear friend, partner Sam, is doing some traveling today, and that little session there we had pre-recorded late last week. Speaking of late last week, I will note that the visa bulletin for May of 2023 is upon us. And I can't say that I'm too happy about its content, but we'll take a little bit of time here to talk briefly about it and put it up on the screen here. There we are. Oh, that's me in front of it. Oh dear, let's make me a little bit smaller here real quick, if I can do it very easily. Well, let's not worry about it too much, and I'll just sort of talk about it for a minute. So essentially, EB1 remains the same. Rest of the world, EB2 retrogression. EB3, rest of the world got a retrogression, and China actually gained 5 months, with India staying the same. So I'll sort of give you my general thoughts on the visa bulletin. Obviously disappointing. One thing that's really kind of truly upsetting is the EB3 final action dates, rest of the world retrogression, all the way back to the 1st of June, 2022. It just means there's less visas, like we talked about a couple weeks ago. When EB3 rest of the world is current, that means that there are visas available for to roll over across the backlog categories, the most backlog being India, of course. And if there's too much demand from the rest of the world, enough to create a retrogression there, it means there's less visas available for India EB3 and that's just not good for everybody, because the bottom line is the people who are most backlogged, it's good when those folks get green cards for everybody else, because if the last person in line is moving, it means the people in front of them are moving as well. I would note that the impact on those who are in the EB3 rest of the world category doesn't seem to be, it's upsetting, but it doesn't seem to be huge. Considering the amount of time it takes to get an improved labor certification from the Department of Labor, that 1st of June 2022 date is really the labor certification dates that are just coming in right now, a little bit beyond that. We're really getting labor certifications from the month of July 2022 right now, and this date's only moved back to June. I don't know how impactful this retrogression is really going to be in stopping new EB3 green cards from coming in. I guess that's the point. So I don't want to deprive you of the time, so what I'm going to do is we're going to move on to our questions here. As I take your questions, please do remember that I'm giving you guys, short, off-the-cuff answers to what could really be complex questions. So please remember, don't make your personal life decisions upon the information that I give here today. We would always, and I'm sure Sam would recommend as well, always recommend finding the advice of a competent immigration counsel before making any important decisions in your life. And please remember that this session does not create an attorney-client relationship between me and you, just by virtue of this strange way of communicating we have here. So I'm going to get right to it, and I'm also going to fix things here by turning off this bottom bar. There we are. You'll get the full view of my keyboard in front of me. So I'm going to start with our first question here from Tiger with 2 R's. So looks like there may have been a first part of this, but I did not see that, even though I know this came in before we started, but here goes. Also, I'm rest of the world in EB2. How bad is retrogression going to be for EB2 rest of the world going forward? So the optimist in me, and those of you who know me know that I'm quite the optimist sometimes, sees October ahead. October, there's a lot of focus during these sessions on the big backlog countries, China and India. But the bottom line is those countries move so slowly, those categories move so slowly because there's a ton of demand from those countries and a relatively small amount of visas. What goes into the rest of the world? That's 100 some countries, and they all get a little chunk of those visas themselves. I am gonna cross my fingers. I'm gonna be looking forward to the October visa bulletin, hoping that the retrogression for the rest of the world stops. Because hey, it's good for those people. They'll get their green cards much sooner, and it's good for the folks in the India and China backlogs as well. This regards to EB2 and EB3. New fiscal year means new visa availability, of course. Gonna keep it moving along here. As always, just keep your questions coming because it gives me something to do. So from Talk to San, I work for employer B. I got my EB2 EAD and AP through employer A. I used the AP at port of entry. My I-94 is valid until 3/16/2024, but my I-797 H-1B is H-1B extension approved last year is valid till 4/2025. As I've not updated the form, I presume that's I-9. What is my current status? H-1B. If I'm not on H-1B, do I need to do anything to update my I presume that this person means I-9 again here. So. Simple answer, unless, and there's, okay, this can actually be a complex question. My question might be, I'm going to go look back at this first half of this question is, hey, when was your H-1B actually approved last year? Is this after you entered on advanced parole or before? I'm not entirely sure, but generally speaking, if you enter on advanced parole, you enter as a parolee, and that's generally what you're going to be in if you use an advanced parole. It may be possible to get back on H-1B status through another H-1B filing. In terms of doing that, this is the sort of thing where I'd say talk to your employer and their HR department, and they may talk to their immigration counsel, and they can talk about what status you're on, whether or not they need to update your I-94. I-94, fortunately, whether you're work authorized is not, or whether the form's completed right, is fortunately not your thing to worry about. That's your employer's responsibility. So, and my AP doc is expiring in October 2023 from Talk to San again. Can I travel out of the U.S. while my AP extension is pending? Will my AP be invalid if I travel out during pending extension? So, first of all, I would just remind everybody to read your advanced parole. Most employment-based, as long as your forms were completed in such a way to request one, and justice-based advanced paroles should be multiple entry. They have no problem giving those. But be sure to check your advanced parole, because exists such a thing as a one-time use advanced parole, and you would hate to find that you leave the United States with an advanced parole that's already been used. But let's talk to the meat of your question. So the general policy from USCIS is that if you exit and re-enter the United States during the validity period, of your advanced parole, any pending advanced paroles you have at that time should not be denied by them. That is the current policy they're operating with right now. So, question from HF. Employer A filed 485 and received EAD AP. Currently working for employer B on H-1. I have plans to go for H-1B stamping. If for some reason I get 221G, can I use the AP from employer A to return to the United States? Yes, you can. It is a separate and valid document aside from the H-1B case. There you go. If I don't go to H-1B stamping of employer B, can I use the employer A AP to return to working for employer B on H-1? So you may be asking one question here, but I'm going to give you two answers. So first of all, I would let you know that the AP is not tied to employer A. It's not tied to any employer. It's tied to your adjustment of status case. So as long as your adjustment of status case is pending and is invalid, so is your advanced parole. So when you're using that advanced parole and you're returning to the US, remember, as I stated earlier, if you're using advanced parole to enter the country, you're not going to be considered to be in H-1B status. You're going to be considered a parolee. There is a policy, an ancient policy from literally over 20 years ago now, from around the year 2000, that says there's a policy by which USCIS may honor your H-1B work authorization if you leave the United States with an employer, say employer B, and you leave the United States working for employer B on H-1B status, you enter back in the United States and return to employer B, they may honor your H-1B work authorization, but you still wouldn't be considered to be on H-1B status. You'd be a parolee. So again, these are sort of things I would talk to your employer's HR department with. But basically, on top of that, it may be possible to get back on H-1B status after you return to the United States on advanced parole through another H-1B filing. So, from Vineet Jain, I have AP valid till August 2023 and apply for renewal. Can I travel outside the U.S. on active AP? Will it impact the pending AP renewal application? So first I gotta say, AP questions are really popular today. I wonder if somebody had a seminar or something, but I can turn this into a seminar on AP and I'll give you the answer to your question, Vineet. So as I stated earlier, when the current policy from USCIS right now is if you leave and enter the United States during the validity period of your existing advanced parole, they should not. It should have no impact on a pending advanced parole. So you know you have a good valid advanced parole for a period of time. You're in the United States. You file for that AP extension. You're going to be waiting a while for that AP extension, but you have a good AP right now. And while that AP is pending, the new one, you leave and enter the United States during the validity period of your current good advanced parole. They should not touch your new AP, your pending AP that's out there. Now, again, this is USCIS, and I can't help but bring up the fact that several years ago, they didn't deny an AP when you had a valid H-1B visa and you traveled abroad and came back, but so be it. From Parth Rathor. So another AP question. You guys see what I mean? Lots of AP questions today. So thank you. Again, Sam's not here today, but I'll do the best I can for you folks. How safe is it to travel on advanced parole? And can you travel while your advanced parole extension is in progress? Because AP extensions are taking very long these days. So I think I'm going to spare giving the answer on traveling while the AP extension is in process. Again, I think I've given a couple times here. How safe is it to travel on advanced parole? So I will tell you one of the first, immigration law lessons I learned, probably my first week on the job. It's who is guaranteed entrance to the United States? Only U.S. citizens and only with a U.S. passport in your hand. You can shout it at the border that you're a U.S. citizen all you want, but if you don't have a passport in your hands, they may not let you in. How safe is it to travel on advanced parole? Well, it seems to me logically safer than traveling on an H-1B visa. You have a document that's in your hand before you leave the United States that says you can return. That seems pretty good to me. Generally speaking, they're not going to require, there shouldn't be too much inquiry. Basically, if you're able to produce that advanced parole alone should be enough to get you into the United States. But there could be 1,001 things that come up. If you have some other ineligibility to enter the United States, I'm going to have to go back to that question about the 221G for example. If I get a 221G, can I use the advanced parole? Perhaps, but if you have some sort of underlying immigration ineligibility that doesn't allow you to come to the United States, I'm going to use my extreme example of you killed a bunch of people outside the United States. That 221G, okay, they gave you a 221G because you killed a bunch of people. Fine. That advanced parole is not going to fix that problem. Advanced parole is not guaranteed entrance to the United States, is the point I'm making. Everything is sort of fact sensitive, and just because you have an advanced parole doesn't necessarily mean you will be guaranteed entrance to the United States. Is the bottom line for me on that one. So another from HF. Some talk in the chat, and I'll look for the answers because I'm always interested to hear about people's immigration experiences. Some from Sriva. I'm on EAD. If a new employer files H-1B, what will happen to the EAD? Will that still be in process? And can I get a green card priority date when it becomes current? So H-1B and your green card and all of its benefits, they are two separate paths. So if you're using the EAD and you're planning to file for an H-1B petition, they generally should not impact one another, and they should not stop giving you EADs because you're on H-1B status. It's the simple answer to that question. It's an interesting question as to whether or not they will allow you to get back on H-1B if you are utilizing your EAD right now, but that's probably beyond the scope of your question. It's the sort of thing where you talk with your employer about that and their immigration counsel when it comes time to file for the H-1B itself. Let's see here. Can a new employer file a new perm and inherit the priority date? The answer to that is most certainly yes. Well, I'm going to clarify your question, just maybe a little bit. So your priority date, for those who don't know, if you're in a labor certification-based immigration tech category, your priority date is the day that some attorney like me goes ahead and pushes click and files to the Department of Labor your labor certification, Form ETA 9089 online. Just did one earlier today. Today is that person's priority date. However, that priority date is not locked in until your I-140 is approved by USCIS. So if you make it to the point where your I-140 is approved by USCIS based upon a labor certification and you got that priority date secured because of that, on your next I-140, after you go through that labor certification process again, you should be able to retain that priority date. But not until the labor certification, not until the priority date is secured by an I-140 approval. Keeping it going here with Animesh Tiwari. So hello, I have I-485 employer filed with employer A, EB2/EB3 I-140. Nice. 45 linked to the EB3. If I change job and using AC21 file I-45J, in case the I-45J gets rejected to a different job profile, can I find another job with EAD? So if I will tell you this, I'm an attorney and I try to basically make sure people avoid that problem. But I believe the most likely result, if they have a serious problem, you send a supplement J. If they have a problem, the likely result is an RFE saying, ooh, we don't think this matched up, likely asking you for your explanation as to, hey, how is this the same or similar occupation? During that time, one, you can produce an argument that says, hey, explain to them this is the same or similar occupation, but another obvious answer is to perhaps find another job that might match a little bit better. So that's a pretty deep hypothetical, though. I think this situation, you really sort of have to play it by ear, and if your I-45J is rejected, you really have to read the reason why it's rejected before you get some good advice on that. But I understand the desire to think about these scenarios, of course. Gopinath Linga. Hi, Sam and Brian. Thanks for all your help you're doing for the immigrant community. I finally got my green card. Well, I know Gopinath, and I'm just going to say thumbs up to that. I am sincerely happy to hear that you made it to the end of the process, and we're always happy to help people. Judge me, I haven't gone through this process myself, but I've been doing my job for a long time, and I like doing it, and it makes me happy. To really, truly does to see you guys get to the end of it, because it gives me hope for the next conversation I'm having with somebody who I have to tell, about that long wait that, people do get there. So from Harsha Ganguly. Hi, Brian. I'm on H-1B. If I receive a federal tax credit for going solar, will there be any impact for my green card? So from the immigration perspective, tax credits are really a something we don't think about. If you, that's it. But from the tax side, which is not an area where I practice, I'd say my first question would be gee, are you eligible for that tax credit as somebody who's not a permanent resident or a citizen of the United States? And that's something a tax professional could probably tell you about very easily. For me to understand any sort of, is there going to be an immigration impact, I'd have to really kind of look about what that tax credit is, what it's all about. I consider it pretty unlikely that there'd be any immigration impact, but I'd have to know more about it, I think. So, from Tiger with 2 R's once again. For some reason, I just find those 2 R's to be a whole lot of fun. How can one maintain green card EAD while staying with the same sponsoring employer, but working with different clients with gaps between clients? Is it safe? So that is a great question, and this is one that kind of gives me pause to think. So, Tiger, I don't know anything about how your green card process was done or who did it, but it sounds like you're an IT consultant, and I kind of have a concern about your scenario. So your green card, if you go back and read your I-140 or your Supplement J, if you submitted one, there's a couple boxes on there that are pretty important. One of is they ask is, hey, is this full-time employment? And the answer is going to be yes in that I-140, of course. Basically, your offer of permanent employment in the United States must be full-time permanent employment. And for me, what you're describing might make it look like that your employment relationship with your employer is not full-time or permanent. It looks to be contractual in nature. And in theory, USCIS could say, hey, we see that you have tons and tons of gaps in your work between your clients. Thereby, they, in theory, could question, the nature of your offer of employment from your employer. And that's kind of what worries me about it. Is that full-time permanent employment if you have those gaps there? Now, as some past version of me has surely said during one of these sessions that, the legal requirement is that your employer is only required to have that green card permanent full-time role ready for you when there's a green card in your hand. However, I'm programmed to be pretty conservative, and I would rather, see you maintaining, looking like, let's put it this way. What I usually tell people is I don't want a government officer to think, that's a really interesting scenario. I want them to think, I should approve this case because it looks just as approvable as the last guy and just as approvable as the next one I'm going to approve. I would try to avoid interesting employment scenarios like that because it doesn't help you, that's for sure. So, another one here from Arun Prasath. What are the consequences of traveling using AP for primary, H4 visa for dependent? Is it okay to travel like this? I can't really say that is a viable scenario. Let's talk a little bit about the nature of that advanced parole and your pending adjustment of status, as well as H4 visas. So, when the primary green card applicant, the H-1B holder, uses that advanced parole, you leave behind your H-1B status. They are oil, H-1B, and water, advanced parole. They do not mix. You use that advanced parole to enter the United States. You are a parolee. You are not somebody on H-1B status. Thereby, your H-4 visas for your dependents cannot be used. If your spouse comes along and I imagine you guys in a very simple scenario. You guys in line at the customs checkpoint. You say I'm entering on advanced parole. And she says, I'm entering on H4. They shouldn't allow that. They might not catch it, but they shouldn't allow it, and you shouldn't attempt to do it because if, in this scenario, entering on AP primary, H4 as dependent, I'd say, technically speaking, she has not been properly admitted. And she has been admitted to the United States, but she's not going to be considered, I guess the term would probably be in lawful status because how can she be invalid H4 without an H1B to lean upon is the short answer of that. So, from Gopinath, we've received our green cards. My green card has a category of E39. My wife's has an E37. Are there any differences between the both? And are there advantages to either of the categories? So, E37 green card category. So, if you guys are wondering what I'm doing, I'm doing a bit of a Google here. Online, you can find published meanings of what those green cards are for, basically one of those categories is going to be saying that hey, you're either you're the primary person in X category, and the other one's going to say you are the spouse in this category, and that's it. So no advantages. Generally speaking, once you have a green card is a green card. That's it. So I have a valid, from Animesh Tawari, I have a valid AP until June 2023. AP renewal is in progress. H-1B stamp till October 2023. If I travel after June, let's say in August, will my AO, probably AP, if I'm looking at my keyboard, renewal will be rejected as I traveled on H-1B. So if you were to travel after June, let's say in late August, yes, in this scenario, your AO renewal, AP renewal should be rejected under their current policy. It's not because you traveled on H-1B, it's because you have left the United States without a valid advance parole. As a note, this is sort of my public service announcement. I know that AP processing times are absolutely brutal right now. If you do have an emergency need, USCIS is usually pretty understanding making requests for emergency advance parole. You can usually get them in probably about maybe a week, a little bit more perhaps. The only problem is that, they usually require evidence of some sort of major calamity, and the typical best case, and I use it because it's really a bad scenario, is that having a sick family member abroad, somebody who's seriously ill. That's the sort of scenario where USCIS, I have found, is really quite willing to give out emergency advance paroles if needed. So what are the current processing times for I-140 under regular processing at the Texas Service Center? Online, it's showing in months. Is it true? For your recent clients, what is the approval timeline? So HF, I think you are right to be a little bit skeptical of the processing times online with USCIS. For one, it of course says 80% of cases, this is the system they put in sometime last year. They says 80% of cases will be gotten to in X time frame. Unfortunately, I don't have that time frame monitored too closely right now for a non-premium I-140. Honestly, I'm not, I'm going to presume that they're not, that the prime time frames aren't that bad because I'm not getting asked too much about them, honestly, is my answer on that one. Nobody's, I'm not having to deal with too many cases where we're putting in service inquiries, for example, because I-140 is taking a long time. So, you're awesome, Brian. Thank you, Parth. Is it a must to file Supplement J? What if I keep changing jobs on EAD while my original sponsor keeps my petition active? So, a great question. So, all you really have to have is an offer of permanent employment in the United States. So if you've talked to, that theoretical employer A, the original sponsor of your green card, and they are perfectly happy to wait on you to basically say, hey, person, we're happy to sponsor your green card, and as long as you come back to us when a green card is in hand, we're good with that. In theory, that is a legally acceptable way to get your green card. To give you a bit of context, Parth, it's a relatively rare scenario, but it used to be when the rest of the world categories were current. I guess sometime we do them right now. Recently, we did an EB1A green card for somebody. It's a very fancy researcher, and that person has never stepped foot in the United States before. And there's no requirement to be in the United States, be in the green card role before that green card is available for you. However, in the real world, I would say, maybe that if you are in a scenario where you are not employed with your sponsoring employer, I'd say it's more likely to be an interview trigger for your green card. Not really recently, like in late 2022, but I would say in late 2021. I would have considered to be an interview trigger to be applying for a green card and not being actively employed by the company that is actually sponsoring your green card. So it is possible to have that agreement with that first employer that I'm going to come back to them when getting a green card. But I think the government would potentially look at it, with a rid of a sniff and a raised eyebrow, and maybe find it to be an interesting scenario they might want to have a talk to you about during a green card interview. Something that crosses my mind. It's hit the 7 o'clock hour. I'm gonna, try to answer the questions I have here. The last one being a lovely thank you, so that'll be my placeholder. And here goes. Hi, Sam and Brian. Will EB3 retrogress again in this fiscal year with interfiling and downgrade? Do you think that a wait time for India EB3 is current is 11 years from your earlier analysis? So, I must, I wouldn't call that an analysis from what we talked about last time. So for those who aren't aware, a couple weeks ago, we were talking about the April visa bulletin. And the April visa bulletin was a bit of a downer, and I was sort of looking for some positive signs in it. And one of the things that we pointed out is if you looked at the data of the visa bulletin over the last 10 years, it really kind of fluctuated as followed, from, it got as low as about 8 years, as high as about 11 years. And I don't remember if that was for EB2 or EB3, or if that held true for both of them. But basically, looking what actual people were waiting for in the real world to get a green card, I think it may have, I don't remember which category it was, but again, we were talking from 8 to 11 years. I am optimistic because the visa bulletin, the crazy visa bulletin movements that we've seen in the last couple of years really did knock people out of the backlog. If you go back to that same video, our April visa bulletin analysis, we noted that they basically issued tons of green cards to people and knocked down the actual backlog of people waiting for green cards in their hands by about 20,000. So that's tons of green cards handed out. Will EB3 retrogress again? I definitely don't have the answer to that one. This fiscal year, I'm going to say, monitor what it says on the end of the visa bulletin here. Honestly, the last visa bulletin, April, which I still have my old copy of here, didn't make much talk of the EB3 retrogression. It said back in March that it might be possible, and I was hopeful previously that because they didn't mention anything about EB3 retrogression on the April visa bulletin, that we wouldn't see it in May. But if you read the end of the May visa bulletin, it says, oh yeah, we mentioned EB3 retrogression back in March, and this is it happening right now. So my honest, there is somebody new-ish at the Department of State who's managing the visa bulletin. The gentleman who was there previously, Charles Oppenheim, left. And all I can say is I am trying to read the visa bulletin conservatively and taking the what they say on it at face value. And a lesson learned from this visa bulletin is just because they don't repeat it on the next visa bulletin doesn't mean it's an impossibility for the future. There you go. You know what would make me really happy? I guess you didn't ask, but I'm going to tell you anyway. That if on this visa bulletin they would just tell us what the availability they have is at a point in the year, how many visas they believe they've used versus what they have available. I think it would, I find that people, even though it's things they can't change, that people would like to have information. And I think that information would make people, okay, maybe not happy to hear, but at least they would know and not have to maybe speculate on the visa bulletin quite as much. From Animesh here, if I returned back to the U.S. Using AP, can I travel to Mexico and return back to the U.S. via land route using automatic revalidation and regain my H-1B? So that's a really detailed question, but my recollection is that you have to actually have status in order to use automatic visa revalidation, and an AP is not considered a status. I have no doubt that some people, I do recall hearing people trying this previously and doing it successfully, but I think if you were to read the automatic visa revalidation procedure, I don't think it's something that they should be doing. But that's the sort of question where I'd say, honestly, Animesh, you'd have to talk about that scenario, your exact facts with a immigration attorney, I'd say. This is the last one I'm going to take here, which is nice because it's the last question here. Can we use EAD to renew driver's license while maintaining H-1B, F-1, assuming 485 to be approved anytime? That's something you're not really using that EAD when you're using to get a driver's license. That's not something we would anticipate having a problem with. I sort of interpret, as I understand it, the folks at your various DMVs and BMVs tend to interpret that as be evidence that you're allowed to stay in the United States, that EAD, and that's perfectly fine. That's what you're using for. You're not using it to work. I don't think you should have a problem with that. Well, it's a little bit past 7. I'm a little bit overdue. My wife is going to be wondering where I am. I'm going to thank everybody for joining me this week. Gonna see you next week this time. I'll be back with Sam, and I will see you guys real soon. Thank you, everybody.